So, Chris, let me start by just congratulating you on this work. It really is an incredible piece of reporting that has been really needed in terms of both because the TPP in particular, and obviously the TTP/IP has not been as exposed to the public, I think, as a lot of it, at least as critics would have wanted over the years. But also because I think this stuff is so Byzantine that people don't really understand the implications of a lot of these things. And so let's start with the four aspects of this ongoing series that you have that have by now been released on BuzzFeed. The four aspects of the I guess the primary part of these trade deals is this investor-state dispute settlement process.
Right. Yes, and this is something that is found in not just trade deals, but in thousands of investment treaties between usually between two countries, sometimes between among a few countries. But it is also in large trade deals like in NAFTA, and as you mentioned, the TPP, Trans-Pacific Partnership. And it is sort of often the least understood or least scrutinized part in some of these trade deals, where you have a lot of attention focused on the potential for the erosion of, for example, American manufacturing jobs or something like that. This is a separate issue that sort of creates a parallel legal system that is private and only accessible to companies and executives.
And so broadly speaking, we're talking about a framework, right? I mean, this is not, when we talk about these investment state investor settlement processes, we're not talking about an institution, right? So this is not like the process may be equivalent to some type of international court, but it's not literally an institution.
That's right, and it is created, really, it's sort of a product of all these treaties. Now, I think it's fair to say that most people consider it sort of a unified system in a lot of respects, in that there are a couple of primary sets of rules, and there are a few large institutions that administer a lot of these cases, but they are just sort of ad hoc throughout the world. You have, essentially three private lawyers most of the time convening in what is often a conference room somewhere, or an office building, or someplace like the World Bank, where they are, these meetings hearings are not usually open to the public, and they are weighing in on issues that frequently have significant implications for public policy and for populations of entire countries.
Is it always three lawyers? I mean, and not just specifically lawyers, but is it always three? I mean, because I know that one is chosen by the industry, right? And one is chosen by the government, that is, I guess, theoretically the defendant. Where's the third one come from?
Right. So the most common is for there to be three, and that is the vast majority of cases. And yes, the third is by agreement of the two sides, or if they cannot agree, it will usually fall to the institution where it's being held. So if you're conducting it under it just depends on where it's hosted and where and what rules it falls under. But that typically means, and this has been another area of some criticism, is that if you can't resolve who the third person is going to be, that it's going to be appointed by then the World Bank, or by, if you're at the International Chamber of Commerce, it's going to be appointed by them, or the Permanent Court of Arbitration, or the Stockholm Chamber of Commerce. So that's what happens in those cases.
And lastly, in terms of this quasi-judicial body, I guess, the the government representative, I mean, the industry representative obviously is a lawyer who's been representing industry interests. This third person is an agreement between the two parties. When a government appoints this third attorney, who do they generally end up being, or is that too broad of a question?
It's difficult to sort of categorize, but I will say for the most part, what you see is that, and in actually traveling to, for this project, I went to El Salvador and Egypt and Indonesia, and also, spoke with a number of officials in other developing countries, and the general perception is that this is a Western system, so most of the lawyers that they select and most of the arbitrators that they select are sort of this smaller circle of people from largely the U.S. and Western Europe. I mean, there are a few others out there, but even within this sort of what they occasionally refer to themselves as the club, there is a pretty. They realize they have a diversity problem, and they've been called, things like, quote, white, male, and stale. It is, it is predominantly private practitioners in Western Europe and the United States who are both the arbitrators and the lawyers, and developing countries really feel like they need to name people with the expertise in this very arcane area of law that really there's not a lot of expertise in the developing world, or at least there hasn't been as much historically. So they feel like to compete, they need to appoint the same people who are in this circle, really.
And also, I mean, I imagine from basically what you're telling us, and I would also I have to sort of put a flag down and say, the fact they refer to themselves as the club is, I think, sort of indicative of one of the problems that people have with this. But you're not seeing representatives necessarily from, the EPA or a labor lawyer or someone whose interests are specifically tied to the government. These are all primarily private industry attorneys who presumably, right? I mean, if they're an expert in this field, it's unlikely they won't be sitting. They won't, or you tell me. Is it unlikely that these people who are ostensibly supposed to be the government's pick are these people who will end up as attorneys for plaintiffs? I guess if you can use that terminology in this situation, or could they be theoretically sitting as the plaintiff's pick in another case?
Right, exactly. You do have some crossover. Really, it's known within. I mean, within this circle of people that there is a major perception problem with what they refer to as the dual hatting problem, where they might be an arbitrator one day and a lawyer. Counsel the next. There are some people, and especially some of the arbitrators who tend to get appointed more by states. There are some who are former judges, or for instance, in one of the cases I described, it's a former Attorney General of Pakistan. But a lot of times it's also just from that same sort of group of lawyers. And in terms of worldview and the type of background that people who practice in the system have, there is a very large number, a large chunk of the population comes from sort of the field of corporate disputes, and they also still spend a significant amount of their time in commercial arbitration, which is, contractual claims between companies. So there's very much a worldview of sanctity of contract and rule of law. And so the primary things in the system are really to protect investors' private property rights And one of the main concerns with this is that we sort of, in international law, enshrined corporations and investors' as their private property rights to a degree, and given it greater protection than we have to things like environmental protection and human rights and climate change and prevention of torture and things like that.
These are not people who are swimming in an ocean where the idea of the commons is necessarily the highest value. We've got to take a break. We're talking to Chris Hamby about his three-part series in BuzzFeed about the court that rules the world, the investor-state dispute settlement mechanism. We're going to take a quick break. Sam Seder, Ring of Fire Radio. We'll be right back.